Welcome everyone, good morning, and thank you for joining our webinar today, Ethics Check, the do's and don'ts of letters of demand and letters of advice. If you'd like to ask any questions, you can do this by typing your question into the box found on the control panel, and you can send questions at any time during the presentation and we will collate these and address them after the webinar for you. For those who don't know me, my name is Katherine Ruschen. I'm a partner in the Insurance and Dispute Resolution team at Bartier Perry, and I'm presenting today with my co-partner, Jennifer Shaw, who is a partner in our Commercial Disputes team. I'll start with dealing with ethical challenges in relation to giving advice, and then Jennifer is going to discuss the ethical issues that arise when you are drafting letters of demand. Okay, so of course, I'm sure we all know that solicitors are held to the highest ethical standards. Many of our ethical obligations are codified as mandatory in all states. And this is because, as stated by the Law Society of New South Wales, your clients are owed your undivided loyalty, subject to your obligation to the courts and justice. You are their fiduciaries and must ensure that you act in their best interests. So just before we go further, I'd just like to say something about the distinction between private practitioners and in-house counsel, because I know we have a mix of both watching today, and we also have some clients who may not be practicing in law, but are dealing with in-house lawyers or external lawyers, and I think it's useful for them to understand how the ethical considerations apply in relation to what their lawyers do. So if you're an in-house lawyer, there is effectively no distinction. We can always rely on Lord Denning to provide a quote on almost every legal topic. And this is what he had to say in relation to whether there's a distinction between in-house and private practice lawyers. So he observed that many solicitors are employed as legal advisors whole time by a single employer. Sometimes the employer is a great commercial concern, other times it is a government department. And in every case, legal advisors do legal work for their employer and no one else. They are no doubt servants or agents of the employer. And he observed that one of his colleagues thought that the in-house counsel were in a different position from other legal advisors in private practice, but Lord Denning, of course, did not think this is correct. He said, they are regarded by the law as in every respect in the same position as those who practice on their own account. The only difference is that they act for one client only and not for several clients. They must uphold the same standards of honour and of etiquette. They are subject to the same duties to their client and to the court. So today's discussion applies equally whether you are a private practitioner or an in-house lawyer. So as I said, each state has a set of rules that set out the professional obligations and ethical principles for solicitors. I won't run through every state. They're mostly the same. There's some minor differences, but I think most of our viewers today are predominantly practicing in New South Wales or dealing with New South Wales lawyers. So for today's purposes, the relevant rules that are rules 4, 7, 8, and rules 10 to 13 in the Australian Solicitors Conduct Rules. And so the conduct rules contain fundamental ethical duties, including the following. So these are some of the key duties. Solicitors must act in the best interests of the client. They have a duty to provide clear and timely advice, and a duty to inform the client about the alternatives to a fully contested adjudication. They have a duty to follow their client's lawful, proper, and competent instructions. And they must not act where there is a conflict between the duty to serve the best interest of a client or their interests. They must not exercise undue influence intended to dispose the client to benefit the solicitor in excess of fair remuneration for the legal services, and they must ensure completion of the legal services. So these obligations must be complied with in all aspects of dealing with clients, including when giving advice. Letters of advice are a very important part of the role of a solicitor, and care needs to be taken to ensure compliance with ethical obligations whilst giving sound, well-reasoned legal advice. And in the last one that's on the screen at the moment, it is implicit in that duty to follow a client's lawful, proper and competent instructions that a lawyer, whether external or in-house, is not able to act on unlawful or improper or incompetent instructions. This is an area where in-house lawyers face heightened ethical and professional challenges that can arise from being employed by their client and thereby embedded in the business. Unlike external lawyers, they can't sack the client, as we sometimes say. Those of you who are managers in a business need to remember in-house lawyers are held to higher ethical standards by virtue of their position as members of the legal profession. And whilst they have a duty to the client organisation for which they work, that duty is overwritten by their primary duty to the court and the administration of justice. So whether your solicitor is in-house or external, they must reject a client's request if the request undermines the primary duty to the administration of justice and the rule of law. So what about the demanding client? So I'm sure we all have a story about the client who always goes unnamed, of course, that doesn't listen to our advice, the one that has their own views about how the matter should be conducted and wants to conduct it in a particular way. And there is also the client that has a relative, perhaps a mother, father, brother, who is a lawyer and has provided a second opinion behind the scenes, usually where they don't practice in the same area of law. These circumstances can be very trying, but the conduct rules guide how lawyers are to behave regardless of the views or wishes of their client. As I said, they provide the ethical framework within which solicitors must operate, and compliance with the rules is mandatory. So a client's instructions cannot override the conduct rules, regardless of how demanding or difficult a client may be. Your professional responsibilities as a lawyer are paramount, and I emphasise again that you are not obliged to follow unlawful, improper or incompetent instructions. And this means that you must reject such instructions from a client if they are contrary to your professional obligations. And if you have a client that insists on providing certain instructions, then you should explain your ethical obligations in the context of those instructions to the client. There are limited circumstances in which a solicitor can terminate a client retainer, but one basis is for just cause. And my view is that a continued or repeat demand by a client to act contrary to your ethical obligations would probably constitute just cause, particularly if the client persists even after you have explained your ethical obligations. So we need to remember that a client's instructions cannot override the conduct rules. Your professional responsibilities are paramount. And as I said, you are not obliged to follow unlawful, improper or incompetent instructions. Okay, so one of the first steps in an advice is summarising the case. And the purpose of the advice is to look after the client's interests by assisting the client to understand various matters that are relevant to the case, but in particular to understand their case and also to understand their opponent's case. It is to assist them to understand their legal rights and obligations and also the consequences of the decisions they make and the instructions that they give to you as a lawyer. Your advice should be clear, frank and honest, and it should be objective in all respects, and it should not be influenced by personal views or your sympathy for the client. An unchecked or unhealthy desire to win a case, for example, can result in an advice being crafted in a way that elicits instructions from a client that will maximise the chances of success in the case, regardless of the alternatives that might be available and might be preferable for your client. Similarly, you can have an unchecked desire to help a client out of sympathy, and this can produce an overly sympathetic advice by summarising the case in a way that is favourable to the client, rather than providing an objective summary of all of the facts of the case. This, of course, may be well intended, but it's not the kind of advice that is in the interests of the client. And it is an area that is where in-house counsel may particularly struggle because of the need to be, or the desire to be, sympathetic to the business for which they work. Okay. So as I've said, there is a duty to provide clear and timely advice to enable the client to understand relevant legal issues and to make informed choices about the actions to be taken. And this means that your client must be informed about the alternatives to a fully contested trial. So, for example, if you're dealing with civil litigation, then you would advise your client about alternative dispute resolution options, as well as the risks associated with proceeding to trial. If you're dealing with a criminal matter, then it would probably include advising on penalty discounts, for example, where they're available for an early guilty plea. So a good letter of advice will not only outline the solution options or the available causes of action, it will also recommend a particular option or a cause of action as the preferred option. It is important for a solicitor not to be influenced by their own personal interests or views when recommending a particular solution or cause of action to the client. You should give an objective and independent recommendation, and you should consider that your recommendation is the best option for the client, having considered all available options objectively, independently, and in the context of the client's circumstances. Your advice should not be motivated or influenced by personal views. For example, that the case should be won at trial, or there is a novel point of law that you are keen to argue. And it also should not be motivated by the potential to generate more fees if the matter proceeds to trial. Okay, so one of the first things that you should consider when you're preparing to give an advice is whether you have all relevant information. And sometimes this is not always possible. In an ideal world, you would give your advice having to hand all of the relevant information and an opportunity to consider that material. But often there are time constraints, and we have to balance this with the duty to give timely advice also. So it can be necessary to make assumptions in your advice. And if you do this, you should clearly state if any assumptions have been made and what those assumptions are. You should state if further information is required. And also if questions have not been asked or issues not raised by your client, which you consider pertinent, then you should identify these in the advice. Many clients do not come to their lawyer with a fully formed legal question. They sometimes have a factual map and a generalised, sometimes vague awareness of they might need advice on some part of that map. They count on the lawyer to spot the issues, and they count on the lawyer to distill the facts, dismiss irrelevancies, and also to focus on the crux of the issue. So don't always assume that if a question is not asked, advice is not wanted. If you're unsure whether it is part of the retainer, you may not have provisioned for it in the cost estimate, for example, then you still need to point out the issues to the client and ask whether they require your advice. And obviously, if that results in a different cost estimate, to give that revised estimate to the client. Okay, so laying it on the line for the client. This is one of the most difficult areas for any lawyer, but particularly I think in-house lawyers, and that is giving unwanted advice. So please, if you are a client, don't shoot the messenger. You need to be mindful that a lawyer's duty is to give honest advice at all times. And in-house lawyers in particular can face a personal conflict when they need to give advice. They know the business isn't going to like, and it might also put them out of favour with their employer. However, lawyers simply cannot compromise their integrity or their professional independence. They need to stick to the legal questions at hand, and if there is a genuine legal concern, stick to their guns and maintain their ethics. As I said earlier, compliance with the ethical obligations under the conduct rules is mandatory. You can deal with this by making yourself a source of sound and fearless legal counsel that people will respect and heed. You can do this by being clear and forthright about legal consequences if your advice is not followed. And importantly, try to put your advice in writing at all times. You might also be able to back up your advice with company policies where you're an in-house lawyer, not just the law. So we all know many businesses will have a comprehensive suite of internal policies that you can leverage to make your point in addition to the law. So just remember that your advice should remain honest and be given without delay. You should not sugarcoat the facts. You can hone your bedside manner by using tactful language. You should be sensitive towards the client's ability to understand the advice. And always remain cool, calm, and collected, even if the client makes it clear they are unhappy. Inappropriate delivery of unwelcome advice can unfortunately lead to further disputes, litigation, or even disciplinary complaints. So it's important to get the delivery right. Okay, so just thought I'd set out some tips for drafting good advice. So first of all, you should use clear everyday language. And at the same time, though, you should not oversimplify complex issues or explain the problem in a superficial way. I think it's useful to start with a summary that states the purpose of the advice. And this way you can ensure the client knows exactly what your conclusions are and will then read the advice with that understanding. So consider using an executive summary at the start of your advice. You should then present the problem and a range of potential solutions. The advice should make sure that the client knows the solicitor understands the problem. And this is where you need to be clear if you have made any assumptions in the advice or whether there is outstanding information that may impact the advice. The advice should succinctly demonstrate your understanding of the issues and the potential solutions before settling on the right solution for the client. So you should not simply outline a list of available options. For example, you have option A, B, and C. Which one would you like? Remember, the client is relying on the lawyer to point them in the right direction as to the best option in their circumstances. So you should always recommend one as the preferred option. So you would say, these are your options and I recommend B. When you make that recommendation, make sure you give reasons for it. So this is why I recommend option B. Your advice should make clear why you as the solicitor are confident the recommendation is the right solution by outlining the proposed solution step by step. Use relevant examples if you need to, such as you may also use supporting case law in a way that demonstrates the solution in a practical way. And you should always know your client's specific circumstances when settling on the best solution that you recommend to the client. So for example, in a commercial case, you should have a good understanding of the client's financial capacity and the ability to pay an amount of money. If it is a personal type of case, such as maybe a family law matter or a criminal law or even a personal injury matter where you're acting for the plaintiff, be familiar with the client's personal circumstances. For example, you might consider whether the client is concerned with reputational issues and minimising adverse impact on their reputation. If so, these should feature in your decision-making process when you settle on the best course of action to recommend to that particular client. And lastly, you should encourage your client to discuss the advice with you. A discussion helps to ensure the client has a complete understanding before they give you instructions. But of course, you should be fully prepared to have that discussion and be challenged by the client on the legal and factual matters relevant to the advice. And by this I mean, be prepared for this before the advice goes out the door. And this is particularly important if it is a case of an unwelcome piece of advice that you are sending out the door. Do your preparation, be ready for that discussion with the client. Okay, so all of what I've discussed applies equally to giving oral advice. Even if you're not putting your advice in writing, those tips on giving written advice apply equally. There's often pressure on solicitors, particularly in-house counsel, to give off-the-cuff oral advice under pressure without adequate time to know whether you have all the relevant information, for example, or even time to consider all the material. These situations should be avoided, so try not to succumb to these kinds of pressures. Try to resist giving advice over the water cooler, for example, and try to request a meeting so you can deliver that advice in a meeting after you've spent some time preparing. Equally, of course, you don't want to set up a meeting and let your client think that this is going to take a long time and that you won't get to the point quickly. So the way to do this is to spend time before the meeting structuring the discussion. So prepare an agenda or a list of points that you can speak to at the meeting. Communicate purposely and don't waste time. And always start with a goal. That is the end in mind. So think about why you are meeting and what needs to be accomplished by the end of the meeting. You might need instructions, for example, by the end of the meeting, or you may need to identify the further investigations that need to be undertaken. So set this out at the start of the meeting. You should then briefly explain the facts or situation that you are dealing with, and then your analysis. And again, even if you are giving oral advice, make sure you make clear any assumptions that you are making and upon which the advice is based. This is important because if the assumptions turn out to be wrong, or even just one or two of those assumptions, then your advice is called into question. However, if you make clear that your advice will be different if those assumptions are not correct, then you have allowed for that contingency. So next you should explain the options as you would in a written advice and provide some detail around each option. Whilst you need to be succinct, you should not cut corners when giving oral advice. And again, make a clear recommendation. Don't equivocate and stick by your guns. Lawyers have to back themselves when they give advice. Okay, so just a final note for our in-house counsel audience today, and also those watching who may not be practicing lawyers but are receiving advice from employed in-house lawyers. So I think it's important to remember, and this is both employer and employee need to remember, that the relationship remains primarily that of lawyer-client as distinct from a relationship of employee and employer. So yes, the in-house counsel will act for the business, but they are not a function of it. They can be sympathetic to the business, but must remain objective. In-house counsel must remain independent, and their ethical duties must always prevail, despite the employment relationship. Good in-house counsel's advice is solutions orientated, as is a good private practitioner's advice. But this does not mean being an appeaser. The discussion that I went through earlier on giving unwanted advice applies equally to in-house lawyers. They must stick to their guns, whether their employer likes it or not. So employers, you must accept and understand the dual relationship and its parameters. Okay, so just in conclusion, I think the key points to remember are that the client is entitled to straightforward advice expressing the solicitor's honest assessment of their case. Legal advice often involves unpleasant facts or scenarios a client may be unwilling to confront, but a solicitor should not be deterred from giving frank and honest advice out of sympathy for the client. Or they should also not be deterred because they think the advice will be unpalatable. This is particularly tricky, as I've emphasised in in-house lawyers, where the risk incurring the displeasure of the people who manage the business and ultimately employ them. However, whether a solicitor is in-house or in private practice, the advice is for the benefit of the client, and it is in the interests of the client for legal advice to be given without fear or favour, and that it is your professional duty. So now you've given, hopefully, the perfect advice to your client and you've received their lawful, proper and competent instructions. What do you do next? And what are the ethical considerations? So I'm going to hand over to Jennifer now, who will discuss this in the context of instructions to issue a letter of demand.
Thank you, Catherine. So my name's Jennifer Shaw. I'm a partner as well at Barty Perry in the commercial disputes team, and like Catherine, I practice in professional disciplinary matters, and I'm going to be talking to you about the do's and don'ts of letters of demand. So letters of demand, debt collection as areas of law go, does tend to attract quite a number of disciplinary complaints, which can lead to findings of professional misconduct or unsatisfactory conduct against practitioners. And I thought it would be worth having a quick look at what those two things mean, as I am often asked. So unsatisfactory professional conduct is defined in the Act as conduct occurring in connection with the practice of law that falls short of the standards of competence and diligence that a member of the public is entitled to expect of a reasonably competent lawyer. There are two definitions of professional misconduct. The first one there being the statutory definition, which is a substantial or consistent failure to reach or maintain the standard. And the common law definition, which was established in the 1894 English Court of Appeal case of Allenson. The common law test is that the conduct amounts to behaviour that would reasonably be regarded as disgraceful or dishonourable by members of the profession of good repute and competency. So lawyers who are acting in debt collection need to ensure that they're familiar with the applicable conduct rules, because a breach of the conduct rules can amount to unsatisfactory professional conduct or professional misconduct. Also the Australian consumer law, the ACCC asset debt collection guidelines and relevant cases, and I'm going to be addressing some of those points. So in relation to letters of demand, I'm going to run through these points in particular. We should not overstate, mislead, intimidate or threaten. I'm going to talk about legal costs and extras, use of language, ethical issues in researching the claim, when you shouldn't take on the work, and a couple of points in particular about acting for mercantile agents. So I've had a look at the conduct rules across Australia, and in relation to this point about letters of demand mustn't overstate, mislead, intimidate or threaten. The Australian Solicitors Conduct Rules, which are applicable in New South Wales, Victoria, ACT, Queensland and South Australia. The most relevant rule there is Rule 34. So solicitors mustn't, in any action or communication associated with representing a client, make any statement which grossly exceeds the legitimate assertion of the rights or entitlements of your client, and which mislead or intimidate another person, mustn't threaten the institution of criminal or disciplinary proceedings against the other person if a civil liability to your client is not satisfied, and you must not use tactics that go beyond legitimate advocacy and which are primarily designed to embarrass or frustrate another person. And in the Northern Territory, have some very similar rules there. In addition there, they've got a rule that practitioner mustn't say anything that must not represent to that person that anything is true which the practitioner knows or reasonably believes is untrue. And in Western Australia, these are the rules applicable there. So maintaining professional integrity, and similar rule there relating to use of false or misleading statements to your opponent. So as you can see, solicitors do need to take care before merely carrying out their client's instructions. And the Victorian Legal Services Board and Commissioner issued some guidelines to the profession about how not to breach Rule 34, and they offered these tips. First was due care should be taken when drafting correspondence to debtors. Check that the appropriate language has been used and that the tone is appropriate. It's well established that conduct is considered to be likely to mislead if it's capable of inducing error. This is an objective test where the intention of the writer is not relevant. It is misleading to imply in letters that certain events or consequences are certain to occur. And so using words such as will and must with care, and where appropriate, use words such as may and potentially instead. It can also be misleading to imply that an event can occur at the sole discretion of the firm when that may not be the case. For example, law firms cannot order a default judgment, and therefore letters should not suggest that that's the case. Now, in addition to the risk of disciplinary proceedings being brought against practitioners who send letters of demand that are misleading or intimidating, there is also the possibility that legal practitioners who engage in this conduct will breach the Australian consumer law, which could result in proceedings being brought against them by the ACCC. And an example of such a case is up on the screen there, Australian Competition and Consumer Commission and Samson. Now, in that case, the Federal Court of Australia made orders against a Victorian legal practitioner who had for many years been sending out letters of demand on behalf of a video rental client. And consent orders were made in that case that the legal practitioner had in trade or commerce engaged in conduct that was misleading and deceptive, or likely to mislead and deceive, in contravention of the then Section 52 of the Trade Practices Act. And orders were made restraining that practitioner from continuing to make such representations, and ordering her to publish corrective advertising, and ordering her to ensure that she and her staff received regular training around Chapters 2 and 3 of the Australian Consumer Law. Now, the Legal Services Commissioner subsequently brought disciplinary proceedings against that practitioner with respect to the same conduct, and the solicitor was found guilty of professional misconduct. Now, I've picked a couple of examples from the Federal Court decision of the types of letters and notices that the legal practitioner had been sending out. So up on the screen here is one such example. This is the sort of letter of demand that was being sent. So we advise that we act on behalf of the client in relation to recovery of outstanding amount of $130, together with $30 solicitor's costs. This amount is required to be forwarded to this office within 5 days, failing which we have received instructions to proceed with legal action without further notice. This will result in added costs to you. Now, you'll see from the letter that an amount of $30 for legal costs has been added where there is no right to payment. And it also represented that the addressee would incur additional costs if legal action was taken to recover the debt, whereas, of course, the client would not necessarily obtain a costs order in the matter. And now here's another example. So this was a type of notice. This notice was a document that the solicitor had prepared and was sending out to debtors, a notice of intention, a creditor's intention to commence court proceedings. Now, this notice represented that judgment could be entered by the firm against the addressee without obtaining an order from the court unless the amount was paid in full. And proceeding was, when in truth, of course, judgment could not be entered until legal proceedings had been commenced and thereafter an order obtained from the court. It also represented that the firm could itself enforce any judgment by means of a warrant, garnishee order, or attachment of earnings, which of course it could not. The true position being that the video rental client needed to be successful in court proceedings, and then an application for such an order needed to be made and granted before it could be pursued. And this notice of intention to commence proceedings was also in a similar format to a document that had been or was capable of being filed in court. And so that was considered a representation that the notice of intention was a document that had been or was capable of being filed in court, when, of course, that was not correct. Now, following the Sampson case, the ACCC apparently wrote to Australian legal practitioners practicing in debt collection, advising them of the federal court decision and asking them to review their debt collection letters and notices to ensure that they were not misleading or deceptive or likely to mislead or deceive. And 3 tips they gave are up on the screen there. So if something is only a possible consequence of not paying a debt, ensure you don't create the impression that it's a definite consequence. Before asserting the right to payment of legal costs or administrative costs on top of the debt, ensure you are aware of whether or not your client has a legal entitlement to claim that amount. And finally, ensure you don't create the impression that your debt collection letters and notices are documents that have been or are able to be filed with the court. And the ACCC, ASIC, have also issued published debt collection guidelines for collectors and creditors with the aim of assisting debt collectors to understand how the Commonwealth consumer laws apply to debt collectors, including solicitors practicing in the area. Now, a couple of further examples of disciplinary matters relating to letters of demand are firstly this Victorian case. Findings were made against the practitioner in this case that the practitioner had made statements in a letter of demand grossly exceeded the legitimate assertion of the rights and entitlements of their client, which misled and or intimidated the debtor and threatened the institution of criminal proceedings against the debtor if the civil liability of the client wasn't satisfied. Now, in that case, there was a finding against the practitioner of unsatisfactory professional conduct and a reprimand. Their letter also gave the false impression that the client was legally entitled to about $1,500 of legal costs when they were not. Now, the Legal Services Commissioner accepted in that case that that letter of demand was the first letter of that nature that the solicitor had sent, and that he didn't usually practice in debt recovery matters. And I think that's probably a reason why there was only a finding of unsatisfactory professional conduct in that case, rather than professional misconduct, as in Sampson. Another interesting case I found is this Queensland disciplinary decision of Singh. In that case, the tribunal dismissed the application against the solicitor. This was a case where a solicitor had sent a letter of demand to a tenant on behalf of his wife and had enclosed a letter that he proposed to send to the police. He was demanding unpaid rent and saying that if he didn't pay in time, he proposed to send this letter to the police to ask them to investigate some earlier checks that had bounced that the tenant had issued, and disciplinary proceedings were brought against him. But in that case, the tribunal dismissed the application against the solicitor and held that the solicitor did not threaten the institution of criminal proceedings. Also, the tribunal wasn't satisfied that the pressure brought to bear on the debtor was improper or unfair. But nevertheless, it would be my advice that to exercise extreme caution before resorting to anything that could arguably amount to threatening conduct when drafting letters of demand, lest you be brought before a disciplinary tribunal to have to explain yourself and defend yourself. And there's another case here from Western Australia. Findings in this case, this also concerned a letter of demand. The practitioner was found guilty of professional misconduct for, amongst other things, sending a letter containing improper threats and inappropriate threatening demands to his client. He was issued with a reprimand and a fine. Now, this was a very interesting case. It relates to a letter written by one solicitor's firm to another solicitor's firm. It was a letter written by the plaintiff's solicitors to the defendant's solicitors, essentially demanding that the defendant's solicitors cease acting for the defendant in the matter. Now, the letter included some very serious allegations about the defendant's solicitors, including, according to the judgment, allegations that the defendant's solicitors had engaged in all kinds of things, such as a grave misstatement of the law, reckless, professional misconduct, complete fabrication, willful deception, connivance. Those were all the types of terms that were used in the letter that was sent. Now, the letter came to the court's attention in the context of a notice of motion filed by the plaintiff's solicitors invoking the exceptional supervisory jurisdiction of the Supreme Court of New South Wales over its own officers to apply for the defendant's solicitors to be restrained from continuing to act for the defendant in the proceedings. But the defendant's solicitors filed their own motion seeking orders that the plaintiff's solicitor's letter and submissions be removed from the court file as scandalous or oppressive within the meaning of the Uniform Civil Procedure Rules, which is up on the screen there. Now, the applications were heard by the court. The plaintiff's motion to have the defendant's solicitors restrained from acting was dismissed. The defendant's solicitors were successful on their motion, and the plaintiff's solicitor's letter and submissions were found to be scandalous and oppressive. An order was made that those documents be placed in a sealed envelope to be retained on the court file and marked not to be opened without further order of the court. And in its judgments, the court stated that it didn't propose to compound the vice in the letter by recording it in any detail, but after rereading it several times and allowing the maximum latitude possible in favour of the author, the court concluded that many parts of the letter could be described as hectoring, hyperbolical in their criticisms of the solicitors, and did not display the sober and dispassionate examination of the readily available objective facts that the court would expect to have been undertaken before such serious allegations could be properly made. Now, I'm not aware of any other case where a solicitor's letter to a fellow practitioner has been declared scandalous and oppressive by the court. The defendant's solicitors sought indemnity costs orders against the plaintiff, and in New South Wales, of course, personal costs orders can be made against legal practitioners who are found to commence proceedings without reasonable prospects of success. So lawyers really do need to take care when drafting letters of demand, whether that's to debtors or fellow practitioners, and ensure that they don't mistake matters. Now, legal costs and extras ensuring the right to payment. So in the Sampson case, the disciplinary proceedings before the Victorian Tribunal, they held that pre-litigation costs cannot be demanded in a letter of demand absent a contractual right to claim such costs, because to do so would be misleading and breach of the conduct rules in that regard. So if there's no contractual right, the letter of demand must not include the demand or request for payment of legal costs in addition to the outstanding debt. Western Australia have a specific conduct rule about this, which is up on the board there. But that's not reflected in the Australian conduct rules applicable to New South Wales, although I see that the Law Council of Australia, the Law Council of Australia's review of the Australian Solicitors' Conduct Rules in February 2018, it had been recommended that our conduct rules should clearly state that a lawyer must not make any statement in a letter of demand that's likely to mislead the recipient to believe that legal costs or other recovery costs are legally payable, unless those costs are legally recoverable based on a reasonable contract or trading terms, and the letter refers to those terms. However, the Ethics Committee did not think in the end that that was strictly necessary, because there are already plenty of conduct rules that say that we mustn't mislead anybody, including Rule 34. Next, our use of language in our letters of demand. We've already talked about the guidelines issued by the Victorian Legal Services Board in terms of language, so using words like will and must with care, and where appropriate, using words like may and potentially instead. In terms of language, it's worth remembering as well, of course, that practitioners are required to be courteous in all of our dealings in legal practice. And some of the relevant rules here, that's the Australian Solicitors' Conduct Rules. It's also in Western Australia, very similar. And I quite like the Northern Territory, they had added in the words that practitioners must avoid offensive or provocative language or conduct. Now, there are a few well-known cases where practitioners have been found guilty of professional misconduct for being discourteous in their communications. These two examples here don't relate specifically to letters of demand, but in my view, they illustrate the point that solicitors must always be courteous in their communications, including in any letter of demand we might draft. So no matter how exasperated we might sometimes feel. The case of Cara George, that concerned which is at the top of the screen there, a case where a solicitor was found guilty of professional misconduct for grossly offensive language in various verbal communications to various persons. And the case of Griffin concerned a solicitor who wrote a letter to a judge couched in grossly offensive terms. In both of those cases, the solicitor's conduct was held to fall within the common law definition of professional misconduct. So in other words, it was held that the conduct would be regarded as disgraceful and dishonourable by their professional brethren of good repute and competency. So letters of demand need to be polite. And I saw that in Western Australia, some guidelines are issued to the profession about politeness, which neatly state that politeness does not prevent effective communication. It's possible to display firmness and resolve in pursuing a client's interests without descending into emotional, insulting, offensive, discriminatory, rude, or intimidatory language. Now, the next issue, ethical issues in researching the claim. ASIC's debt collection guidelines for collectors and creditors state that a debtor must not be pursued for debt unless there are reasonable grounds for asserting the person is liable for the debt. The Victorian Legal Services Board and Commissioner's guidelines state that collectors should not rely solely on client instructions without making any additional inquiries or requiring proof that there is liability, such as the existence of a contract, terms and conditions of invoices, and the same applies to lawyers acting for debt collection agencies. So that's something to be careful of, is just taking the client's instructions without checking relevant invoices and contracts. So when should you not take on the matter? Well, we're obliged to follow, as Catherine said, our client's lawful, proper and competent instructions. As Catherine said, that doesn't mean that we have to follow every instruction that our client gives us. The emphasis is on lawful, proper and competent. It's often been held that solicitors are not mere mouthpieces of our clients, and that we need to act professionally and exercise independent judgment. So if the client instructs us to do something that our professional responsibilities don't allow, then we should advise the client that the time to act, and the client assists in that course. Now, this next slide relates to acting for mercantile agents. So when acting for mercantile agents, it's important to seek proper instructions and formal authorization directly from clients before initiating proceedings. And on the screen is the Law Institute of Victoria's guidelines about this. And in the Legal Profession Uniform Legal Practice Solicitors Rules, Rule 7.1, says that the solicitor must not allow the solicitor's business name or stationery to be used by debt collection or mercantile agents in a manner that's likely to mislead the public. And also, a legal practitioner who receives from a debt collection or mercantile agent instructions to act on behalf of the client must ensure these things: that your relationship to the agent is fully disclosed in writing to the client, the information required to be disclosed to the client by any relevant legislation and the rules is communicated to the client, that the solicitor maintains direct control and supervision of any proceedings and correspondence on behalf of the client, and finally, that any money recovered is accounted for by the solicitor to the client. Finally, if you have paralegals or other unqualified staff running lots of debt recovery work in your practice, it's worthwhile remembering that they must be supervised by an appropriately qualified legal practitioner when undertaking any legal work. And the Legal Profession Uniform Law contains a specific prohibition, which is up on the screen there, in relation to engaging in unsupervised legal practice. So in conclusion, with your letters of demand, don't overstate, mislead, intimidate, and threaten. Ensure you have a contractual right to claim legal costs. Make sure that your letter is courteous. Make sure your client has a valid claim to the debt. Don't act as a mere mouthpiece of your client. If you're being asked to do something that could place you in breach of the conduct rules of ethical duties, don't do it. Take particular care when acting for mercantile agents that you seek authorization direct from clients and before issuing proceedings, and provide all the required disclosures, and ensure that you supervise your paralegals and employees. Now, we'll be sending you, that's the end of our presentation, we'll be sending you a copy of these slides and also a paper, and also I think a link to the recording. And finally, I wanted to mention that at Barty Perry, we do have a value add service for clients of a $55 letter of demand, and in our email to you, we'll include a link with some further information about that product in case it's of interest to you. Thank you very much for listening. I hope you enjoy the rest of your day. Thank you.